So are there any exemptions to this?
Exemptions in the form of what?
So like I want to come up with only a a website, several law, but I'm not going to be doing, I don't have a physical location.
So there can't, one of the tricky parts about the legal landscape is
maybe a law firm is a bad example. I only sell product online. Maybe that might be a better. I want to make it simpler because I know there's a case that's on point. I guess I'm trying to lead you towards that case, but you can talk about that.
Well, yeah, as you know, in California, online only businesses can no longer successfully be sued, but of course, the ADA is a federal statute. It applies across the 50 states and within the 11 circuits that can potentially hear these types of matters. So while that is going to lessen litigation, it doesn't mean that that litigation has ceased.
Right, they're scot-free. Got it.
Yeah.
Because again, they are the reality also is, and sorry, again, I'm interrupting. I have a bad habit. I know there are plaintiffs firms that straight up will still file, knowing that they know defendants will settle. They're counting on that. And the reality is, if the attorney doesn't know or is not aware, like you mentioned, of all the things, they'll push for. I'm on a Facebook group in our thing for LA Attorney. It's an LA Attorney Network group, right? And then anytime somebody says, "Hey, I have an ADA website case," and the first thing everyone says is just settle. That's the kind of become the go-to. Like, there's no discussion now. I'm like, yeah, there are ways you can probably handle this, especially if you find out, do they have standing? Did they really try to visit a website? Because the reality is, maybe they didn't. They just sued you because they know people don't look at it. These are like template complaints that are being sent out to hundreds of businesses.
Well, the plaintiffs' law firms that are active in this space are relentless, and that has been shown time and time again. So that does not surprise me. But I do think there is an asymmetry that exists. So I understand the default to settlement, because this is litigation within the infrastructure of these plaintiffs' law firms. It's not a big cost to them to file a complaint or send a demand letter, but to the recipients of litigation, right? It's like we've just ruined our week, right?
Yeah, the clock starts ticking, right? Ultimately, as soon as they sign, that's the bad news I gotta give them. Hey, you gotta pay me because I gotta do the work. Unfortunately, they're just they take contingency cases and they get a percentage, and their incentive is attorney's fees, and they hype up these attorney's fees. And I recently settled a case where they wanted $25,000 for writing a demand letter and filing a complaint. And I'm like, really? You really think the court's going to actually grant you that for filing two pieces of paper? Yeah, so I thought that was interesting.